Welcome to Influential Entrepreneurs, bringing you interviews with elite business leaders and experts, sharing tips and strategies for elevating your business to the next level. Here's your host, Mike Saunders.
Hello and welcome to this episode of Influential Entrepreneurs. This is Mike Saunders, the Authority Positioning Coach. Today we have with us Rich Goldstein, who is a patent attorney. Rich, welcome to the program.
Thanks, Mike.
Hey, so I'm excited to talk to you because I think many people, as you know, watch the Shark Tank, and every other time it's like, do you have a patent? And oh, it's provisional. It's this. It's like, ugh, what in the world? So I'm certain that there's a lot of entrepreneurs that are so confused with what a patent is, what it does, when they need it. So I'm really excited to talk to you. But give us a little bit of your background. How long have you been in law and practicing focused on patents?
Thanks, Mike. Yeah, and people really do wonder about this stuff. I mean, so few entrepreneurs really understand how patents work, although it could often be the thing that makes the biggest difference in their business if they just understood it better. So I'm passionate about educating people about patents. And how I got into this is I originally studied electrical engineering, and I realized that being an engineer meant working on the same project day in and day out for years at a time, and that just isn't my style. And so I heard about patent law, I went on to law school, and now I get to work on something different every day, which is awesome, and I've been doing it for 26 years.
Wow. And, you know, isn't it similar? It seems to me that it would be similar to the medical field, where if you're a general practitioner or a general, doctor, then you can see a lot of different things. But then when you go focus on podiatry, then you only focus on the foot. Well, you have moved from being a general practitioner to a patent attorney. Is that a good comparison?
Yes, and it's kind of like it's for good reason, in that to be a patent attorney, you need to be an engineer and a lawyer. So I kind of started out headed down this path, and anyone who graduates law school can practice general practice law, but you have to be an engineer to be eligible to be licensed to be a patent attorney.
Now, that's interesting because I did not realize. I would have thought that it's just you have your law degree and now you just bone up on patents and you're good to go. And if you need a divorce, don't call me. Or if you need, but yeah, you need to be an engineer. Now, is that a credentialed engineer? You need a degree in engineering?
Yes, you need a degree in engineering, or, I mean, technically it could be like a degree in physics or a degree in chemistry, or one of the, like a science degree. Okay. In order to be eligible to do that. And it's funny, most people don't realize that. And when I was in law school and I told my friends about that, I was going into patent law, they thought like, wow, that sounds really good. Maybe I'll do that. I was like, well, what did you study in undergrad? They're like, political science? Like, it's too late. Sorry.
Wow, okay. That's really good. That's really, to me, that is good to know, because if someone just assumes that you took an extra course in law school and patent law, well, you know, what kind of background and foundation do you have? But you got a degree in engineering and you're now going to talk about patents. Now, you could get a patent and have nothing to do with engineering, but it just goes to show you that it's a couple notches more than just having that general practitioner. So that's a really, really great clarification. What I would ask is, as an entrepreneur, what do you advise your clients is the right time to start thinking about and then moving toward patenting their idea?
Okay, great question, because this is where a lot of entrepreneurs go wrong. And that is, you want to think about it before it's public, before you put it out there into the world in any way. And people often think, well, maybe that's because, well, once it's public, someone might steal your idea. But there's more to it, in that even if no one stole your idea, if you make it public before you apply for the patent, you immediately lose the rights in most of the world. And in the U.S., if a year goes by, then it's too late. So in the U.S., there's technically still a 1-year grace period, but I can't tell you how many times people have come to me 2 years after a product's been out there on the market and said, my product's doing fantastic, I need to patent this. And when I find out that it's been out there for more than a year, I have to tell them that, hey, I'd love to represent you, but we can't do anything because it's too late. And entrepreneurs just don't know that. They just don't know that you could lose the rights by putting it out before you apply for the patent.
Now, is it literally you can't do anything in that moment, at that time frame, or is it more you can do it, but good luck and you don't have a firm foundation to stand on?
No, you lose the rights. Like under the patent laws, if you are not eligible for a patent anymore, and actually no one is. So then it's just public domain. Anyone could do that idea, can make that invention. It's just you've lost the right.
And that's really good to know, because I'm a entrepreneur for 10 plus years, and I watch Shark Tank, and not that that's the educational divining rod, but that's new and that's good to know. But here's something that I would think is, you've heard of the concept called proof of concept. So here's an entrepreneur that would go, well, Rich, I'm not going to spend a bunch of money on a patent. I don't even know if it's going to have a proof of concept. I want to get it out there. Well, how do you balance that?
Yeah, it is a little tough to balance, and in general, in terms of proving the concept, I mean, you try to do that as privately as possible. Okay. But to an extent, you want to get your feet into you want to test the waters. You want to dip your toe in and find out if people are really interested in this. And so it's challenging to be able to do that. If you haven't applied for a patent, I mean, one thing that people do is they'll file what's called a provisional patent application, which is essentially your foot in the door at the patent office. Okay. And it's less expensive to have that put together for you. And this way you can get it to a patent pending status, and then you can go out into the world and talk to people about it to see if it makes sense to really go all in. And not every invention should be patented, but the time to consider it, to take a close look at whether you want to do something about patenting it, is before you put it out there.
And so the way to kind of put a stake in the ground is to go provisional, and then you can move forward and get your proof of concept, test the market, and then since you've already done the provisional, you can move to the next step out there.
Yep, exactly.
Okay. Good.
Exactly.
So then I guess what I would then ask is, there's a lot of ideas and concepts and procedures and technologies and all of these things. How would an entrepreneur know if their thing, their idea, their product is worth the hassle and cost and time to patent it? What's some of the things like, well, if it's just this, then don't worry about it. Or now when you start moving into this type of thing, now is when you need to start thinking about patenting that idea.
Yeah, great question. And I'd say the thing you really want to know in order to figure that out is how new it really is. Yeah. Because what you want to do is figure out, what would you be getting a patent on? I mean, people think about a patent as like this abstract thing, like, oh, there's a patent on that product. It's patented. Well, not exactly. It's more like some aspect of that product was new, and that's what the patent focuses on. So what you want to figure out is, if you were to get a patent, would it focus on anything that's important? So what we want is a patent that focuses on the overall concept of a new idea, and then that's valuable, because then that would prevent anyone from following that concept. But too often, it turns out that the concept wasn't as new as you thought it was after you do some research, and so then you might see that, okay, well, there's some details about it that are different. Then you have the choice of whether you can get a patent on those details, but there's the question of, is it worthwhile? Would your potential customers care about those details? So in other words, like, if the thing that makes your invention unique, are your customers going to insist upon those features? And then because they're doing that, are your competitors going to look at it and say, well, if we can't make it with those features because he's got the patent on it, then let's not bother even trying to compete. Then you have something worthwhile. But a lot of times, what you have available is to patent some details that people don't care about. People don't really care about if that release lever is curved at the bottom or whatever. And so if that's what you can get a patent on, then it's not worthwhile.
Yeah, and Now, then again, here's a question for you. As you know, I'm the authority positioning coach, and so I like to watch for areas that would set yourself apart from your competition in business. Is there a time that you feel an entrepreneur would be kind of like on the fence, like, well, you could patent that, and it's wonderful, but if you didn't, it's not the end of the world. But what if you move forward to patenting that idea for the purpose of being able to use that in your business development, your marketing, and then that would elevate your brand in the mind of the consumer in your target audience? Would that be an element to consider?
Yeah, certainly. I mean, but that's something you want to go in with your eyes open.
Yeah.
If you realize that all you can patent are the details, and that you're going to apply for a patent so that you could say that it's patent pending, then that's great. I mean, you've gone in knowing what you're getting. You're not under the illusion that you're going to get a patent that actually protects you. You're thinking that it's going to have that marketing benefit, and that's the reason you're doing it, and it justifies the cost of applying. Then great. I think most important is for entrepreneurs to know why they want to go into the process, why it's worthwhile. And as a matter of fact, the very first chapter of my book is about why you want a patent and really taking a close look at those reasons, because that's the most important thing to consider up front, is making sure that your expectations are in line with what's possible.
Yeah, that's really, really a great point. Now, so let's think about something else here. I can't place the person's name, but I interviewed someone on my show a couple of years ago, because I'm at like 549 episodes, and this was quite a while back. But it was someone talking about patents, and they took a contrarian approach, and they said it's almost to the point where don't bother, because if you're not able and willing to defend a patent, your patent, if someone comes up against it, then it's not even worth having. What is your approach, or what is your thoughts on that approach?
Yeah, I mean, my thoughts are that you don't get a patent to have the privilege of spending $1 million bringing a lawsuit. You get a patent because it keeps 80% of the people away. Okay. There'll always be some people that want to call you on it and want to challenge it, right? But 80% of the time, people will be deterred when they see that it's patented. Even without looking it up and knowing what the patent actually stands for and how strong that patent is, they will be deterred. And then again, when it's really worthwhile, I mean, if there's enough money at stake, then it's worth going after them. So if they've ripped you off and is $5 million worth of royalties that you've lost out on, then it's worth going after them, and you'll be able to recoup those losses, those profits that those royalties that you weren't paid.
That's a really big point that you bring up, because it's like there's always, like for instance, you can go off the grid as much as possible and try to protect this and get your ID protection, all that stuff, but someone out there can hack something, right? So you can't ever be totally protected. So with a patent, if you're using that number 80%, that's not an exact number, but what if the patent protects about 80% of the potential down the road? Well, then you're only exposed to 20%, and most likely anyone that would think of coming up against you sees patented, they're going to go, I don't have the stomach for it on their side. So that's a really good point to consider. So I think that I think that's really great to keep in mind. What if, when you think about patenting an idea, can you patent a name or a concept in your business, or does it have to be a physical product, or can you patent a process, Mm-hmm.
Well, actually, physical products and processes can be patented, but if you're talking about the name, then that's really what a trademark is for. And it's also with the Patent and Trademark Office that administers getting a registered trademark, but it's a different process, and it's the way that you would protect a name so that other people can't use a similar name to confuse the public into thinking they're you. Like, if you're Coca-Cola, then you want to prevent people from naming their product and having a logo and having a color scheme on the can that would confuse the public into thinking like, oh, this must be Coca-Cola also. That's what trademarks are for.
Got it. What are some of the mistakes, the most common mistakes that you see entrepreneurs make? And I would suspect that one of the biggest is what we said at the very beginning, which is getting
Yep.
your idea out there and not taking steps ahead of time, and then now it's too late. But what else?
Yeah, exactly. Yeah, that's the biggest one is by not acting in time. And I'd say the other one is realizing that every patent has a scope, that it is it's not an absolute. It's like every patent. Some patents are broad, and cover a whole concept, and some patents are very specific. And I think on like the other side of it, as an entrepreneur who is thinking of entering a business, and then you see that a product is patented, they are too often too easily deterred when they see a patent. And really what they want to do is to look further into it, because the patent might not actually be preventing them from entering that business. So a big mistake they make is believing that just a patent is too valuable. And I've even seen cases where people have like done a little research and they found the patent number, and they said, oh, well, it looks like this person has the patent on my idea, and they've contacted them and spent $50,000 to buy their patent from them. And when I looked at it, I said, you didn't need this patent. It didn't cover the idea. It was for something very specific that didn't matter to you. So I'd say a big mistake they make is just not looking further into what that patent might stand for and how it relates to their business goals.
Yeah. Well, let's kind of land the plane and talk a little bit about your book. Give us, I know you wrote it 3 years ago, but give us the background on the book, what it's for, and what readers can glean from it and take away.
Yeah, well, it's the American Bar Association contacted me and asked me if I would write a book to explain to entrepreneurs how patents work. And they actually, it's kind of funny because very often people pitch them on having them publish the books, but they actually approached me because they saw that I was out there talking to entrepreneurs in plain English, really explaining how all this works. And so they asked me to do that in book form. And so what I created it's called the ABA Consumer Guide to Obtaining a Patent, and you can find it on Amazon. It's less than $20. And if you read that book, it's basically, I'd say it's about a 4-hour read. And if you read that, then you would be in the 99th percentile among entrepreneurs of how well you understand how patents work.
Now that is pretty exciting because I think it kind of reminds me back I don't know when the old Dummies books came out in the 80s or whatever, but it's kind of like just show me the easy stuff. Don't get into don't make it feel like it's a textbook. I don't want to read a textbook, but let me understand what 99% of the other entrepreneurs out there don't understand in a 4-hour read book. Now you're talking. That's pretty cool.
Exactly. And it's written pretty much the same way that I speak. So if you found me to clearly convey these concepts in a way that just makes sense, then that's how the book is written. And that's how it reads. Just me talking to you, explaining how this works, explaining what you ought to know as an entrepreneur about patents.
Excellent. Well, Rich, thanks for coming on. Let me just have you tell us what's the best way people can reach out, pick up a copy of your book, as well as connect with you on your website and teachings and listen to your podcast.
Okay, yeah, a few things. Well, first of all, regarding the book, I mentioned the first chapter about why you apply for a patent. That's actually a free download at patent-book.com, so like patent-book.com. If you want to learn more about the process, you can check out my website, goldsteinpatentlaw.com. And also, I do a live Q&A every week on Friday. And if you want to sign up for that, just go to goldsteinpatentlaw.com/office hours. And you can sign up. You'll get notified about that, and you can show up and ask your questions.
Excellent. Well, Rich, thank you so much for coming on. It was really great talking with you, and I'll make sure we have the link to both your website and the book download in the show notes. Thanks again for coming on.
My pleasure. Thanks so much, Mike.
You've been listening to Influential Entrepreneurs with Mike Saunders. To learn more about the resources mentioned on today's show or listen to past episodes, visit www.influentialentrepreneurssradio.com.